Hi, this is Dr. Cora Stack here. I want to talk about a final paper on the protective disclosures regime that I've been working on, really examining it since 2014. And this is a kind of consolidation of all my work since 2014, a bit like the Mayo team yesterday in Croke Park. So I had the honour of being there and seeing my native county being defeated, but nobody from County Kerry would begrudge Mayo, holding the Sam Maguire, for the year and sharing the joy of having it in County Mayo. So the very best of luck to all the Mayo people, and they certainly won the singing competition. I mean, the first part of the entertainment was the singing, and I mean, by any stretch, Mayo were far better at the singing, and the song that they sung was I'm afraid when once they won the singing competition, the game was over really. Anyway, that was my opinion when I heard the two songs. Well, we leave it at that. That was just a fun part of it. So, acts of omission and the practical weakening of the separation of powers in Ireland. So I'm announcing the completion of a major new paper entitled Acts of Omission, something I've been trying to understand for many years, and I'm linking it in now with malignant narcissism, coercive control, and the weakening of constitutional democracy over time, and all of that, and how it all happened. So I see it all really as coercive control and malignant narcissism, and I think it's all there if you understand malignant narcissism or coercive control. This is all these are all the manifestations of these behaviours or tactics. So this is another line of inquiry, the isomorphism between all of these to be established in due course. The isomorphism is a kind of a one-to-one and on-to correspondence between two mathematical systems. So how the Protective Disclosures Amendment 2022 and the framework it established may keep serious institutional wrongdoing from independent judicial determination. I suppose it's the erosion of human rights. You could maybe map it onto human rights as well. So this is a substantial paper of more than 180 pages. It represents the culmination of many years of research, beginning in approximately 2014 into protective disclosures, whistleblower protection, institutional accountability, access to justice, which I have a huge pillar on that on academia.eu. It's something that's really important, I think, for justice, and I'm trying to understand how there's really huge problems globally and in Ireland for access to justice, and how that can be, how we should be dealing with that, and the constitutional separation of powers. For the time being, this paper completes my principal body of work on protective disclosure. The starting point is very simple. Most people understand wrongdoing as something actively done. They may understand corruption, not a lot of people understand that, fraud, falsification, deception, cheating, abuse of power, or deliberate manipulation of a decision. So far fewer people understand the more covert form of wrongdoing, that serious wrongdoing can also occur or remain concealed through an act of omission. A complaint may not be investigated, evidence may not be preserved, a central witness may not be interviewed, hidden, just a conflict of interest may not be disclosed. That's a huge issue. False or materially incomplete information may not be corrected. Relevant records may not be obtained. A person who reports wrongdoing may not be protected. An omission can therefore become much more than passive inaction. It may become the means through which wrongdoing is hidden, responsibility is dispersed, and accountability is prevented. The central argument of this paper is that when an act of omission is made exceptionally difficult to prove, and I talk about all the barriers, the gates in the new legislation that have been, put up in the design, it is unlikely to be corrected. So that's a key point I'm making here, that if an act of omission is made exceptionally difficult to prove, it's very unlikely to be corrected. When it's not corrected, the underlying wrongdoing may remain hidden or concealed. So when this occurs repeatedly across public institutions, accountability weakens. Over time, that may weaken the rule of law, democratic accountability, and the practical separation of powers. A major concept developed in this paper is the omission evidence paradox. It's like the circular reasoning that I was talking about, and it's something that it's really, for a logical brain, when you see circular reasoning, it's kind of like infuriating when you see people using circular reasoning, and they're so convinced of their reasoning, and they're so convinced, and you see the circling in the reasoning, and they're so persuasive and so convincing, and it's going around like this, and you're saying, so it's kind of self-justification, if you like. So for example, a person may report that records were not created, evidence was not preserved, a witness was not interviewed, or this is like forensics, or information, important information was withheld. The reporting person may then be asked to provide prima facie evidence of the omission. But the evidence needed to prove the omission may be controlled by the institution whose conduct has been reported. This is why I'm very concerned about what I call the prima facie gate, because I can see this arising. The person may need an investigation to obtain the evidence, yet they may be required to produce the evidence before a full investigation begins. The omission may therefore defeat its own investigation. This paper examines whether the framework established by the Protective Disclosures Amendment Act 2022 contains too many administrative gateways between the reporting of serious wrongdoing and its independent determination. These may include worker status restrictions, the requirement that information arise in a work-related context, the possible reclassification of serious wrongdoing as an interpersonal or personal grievance, another deflection, prima facie evidence gatekeeping, controlled by the organisation to whom the wrongdoing is reported, administrative transmission between bodies, again it's fragmentation, restricted terms of reference, institutional control of evidence. I mean, this is a huge conflict of interest problem. The institutional control of evidence, and again, conflicts of interest, the absence of guaranteed legal representation. I mean, it's like it could be against a wall of legal advisors and in a protective disclosures investigation, and you could be by yourself, and that's considered proper, and. I mean, is there any equality of arms here in this situation? Limited opportunities to challenge adverse evidence. I mean, if you have no knowledge of, if you could have 6 or 7 in an investigation and you could be there by yourself, and what chance have we got of proving the wrongdoing? And then there's no right of reply, or I mean, it's fragmented responsibility, delay, short limitation periods, and the cost of reaching the courts. No single barrier necessarily proves that the legislation is constitutionally defective. Again, the concern lies in the cumulative operation. So, I mean, we work a lot with cumulative distributions and probability and statistics, and that sort of thing. We understand the power of the cumulative as opposed to the discrete once off versus the cumulative operation of anything. So, a person may successfully make a report. That report may be acknowledged, it may be transmitted, feedback may be provided, an administrative procedure may take place. Yet the underlying corruption, fraud, concealment, abuse of power, or act of omission may never be independently established. The system may therefore become highly effective at processing reports without being equally effective at resolving the wrongdoing reported. One of the principal conclusions of the paper is that the current framework may be administratively elaborate, but investigatively, adjudicatively, and constitutionally incomplete. So you have this huge layers of administration doing all of this transportation, moving things around. But when you really look into the whole body of what's going on, there are major questions about investigation. How much time and energy and resources is devoted to investigation, adjudication, and constitutional review. Administration is necessary. Reports must be received, recorded, transmitted, and assessed. I mean, there must be millions and millions spent on all of this stuff, and nothing is investigated. Well, I won't say nothing is investigated, but we never hear of anything ever being actually investigated. It's all this reports going around here, there, and everywhere, and then gates stopping them from going anywhere else. But administration is not the same as investigation. Investigation is not the same as adjudication, and compensation is not the same as correction. The legislation provides important remedies where a reporting person suffers penalisation, but really the only people that really benefit here are people that have significant resources for legal representation. And that's very hard to find. So those protections are essential and should be retained. However, there is this is where I see a fundamental flaw in the design, just looking at it now, for a long time. However, there is a fundamental distinction between determining what happened to a person before they reported wrongdoing and determining whether the wrongdoing they reported actually occurred. A person may receive compensation for penalisation, and they're very lucky if they can find a solicitor or a legal team to help them. Extremely lucky. The institution of wrongdoing, however, may remain entirely uncorrected. The messenger may receive a remedy. The message may remain unresolved. This is the remedial imbalance examined in the paper. The constitutional foundation of the analysis, my favourite article, Article 6 of the Irish Constitution. Article 6 establishes that the powers of government derive from the people and are exercisable only by or on the authority of the constitutional organs of the state. The paper does not argue that every administrative investigation is unconstitutional. No, I'm not a black and white person, absolutely not. I'm very much centred in my thinking. Administrative bodies perform essential functions. Article 37 also permits non-court bodies to exercise limited functions of a judicial nature in non-criminal matters. The constitutional concern is more subtle. The courts may remain, again, it's very like the constitutional, the other paper that I wrote, the courts may remain formally available while becoming practically inaccessible as a result of the design of the 2022 Protected Disclosures Amendment Act, which, as I understand, was never referred to the Supreme Court for its determination or review. An administrative body may determine whether the person qualifies under the legislation, how the disclosure is classified, whether sufficient preliminary evidence exists. This is the prima facie gate, where the report is transmitted. That's usually the duty of the commissioner, but I suppose it can move from one, can move move around. What falls within the investigation, what evidence is obtained, and whether the matter is disclosed. If the wrongdoing remains unresolved, the reporting person may then be told they must go to the court personally. They may receive no guaranteed legal representation. They may have no access to institutional controlled evidence. They may be required to identify and finance complex proceedings themselves. An administrative closure is not formally a court judgment, but when the reporting person has no realistic means of challenging it, that closure may become functionally final. I describe this as the procedure displacement of judicial accountability. The courts have not been expressly excluded. Instead, cumulative administrative, evidential, procedural and financial barriers may prevent the matter from reaching them. This raises the central constitutional question: does the cumulative operation of the protective disclosures framework practically weaken the court's capacity to check serious alleged abuses of state and institutional power? The problem becomes especially serious in elections and constitutional nomination processes. These events operate within strict and irreversible time limits. A nomination period closes, ballot papers are finalised, votes are cast, the election becomes final. If an alleged abuse of power is not investigated, if evidence is not preserved, or if urgent judicial relief cannot be obtained before the deadline, the constitutional opportunity may be permanently lost. This produces the sequence I've identified elsewhere in my research. Before the event, the case may be regarded as incomplete or premature. During the event, intervention may be regarded as disruptive. After the event, the matter may be regarded as irreversible or too late, often referred to as moot. The constitutional issue is never independently determined, while an effective remedy remains possible. This is what I call the constitutional blind spot created by time. So this is introducing the time dimension into constitutional analysis. This is my contribution to this whole area of constitutional law. The paper also examines the significant worker status problem. This is a huge issue. A candidate, voter, citizen, councillor, service user, or other person interacting with a public institution may possess credible evidence of serious wrongdoing without satisfying the statutory definition of a worker. This is a huge axis to trying to resolve wrongdoing in institutions. This barrier of the definition of a worker, inverted commas, a determination that the person is not a qualified worker does not prove that the wrongdoing did not happen. It proves only that one statutory route may not be available. The legal status of the messenger may determine the protection available under one act. It should not determine the constitutional or public importance of the message. This paper proposes a more coherent model based upon immediate evidence preservation, independent preliminary assessment, separate consideration of worker protection and public interest wrongdoing, an omission-sensitive prima facie test, independent conflict of interest screening, fair and independent approved terms of reference, a meaningful right of reply, legal representation proportionate to the seriousness and complexity of the case, independent merits review, supervisory continuity after a report is transmitted, urgent procedure for electoral and constitutional matters, and a public interest mechanism through which serious unresolved wrongdoing can be brought before an appropriate tribunal or court. The proposal is not that every disclosure should automatically become litigation. This would be disproportionate and unfair. The proposal is that serious public interest wrongdoing should not disappear merely because the person reporting it lacks the evidence, legal expertise, or financial resources needed to commence proceedings alone. The framework should protect the reporting person. It should investigate the wrongdoing. It should provide independent review. And where necessary, it should create an effective bridge to judicial determination. This paper brings together more than a decade of reflection and research. It draws upon my wider work on protective disclosures, active omission, procedural traps, institutional protective layering, burden reversal, access to justice, constitutional accountability, electoral finality, and the constitutional blind spot. The research began around 2014 and developed gradually as I observed recurring patterns across employment law, public administration, protective disclosures, and constitutional processes, among others. My mathematical background has been extremely important to this work. I've approached the problem through patterns, sequences, cumulative barriers, and the interaction of multiple procedure stages over time, and also years and years of study of narcissism, inverted commas, and psychology, and the dark territory. All of that really was foundational in terms of moving to what I've done now. The whole study of psychology for years and years and years, trying to understand the complexity of narcissism and the dark territory and all of that. That was a real eye opener for me in terms of seeing everything as a manifestation of patterns of malignant narcissism or of coercive control. So the central difficulty is rarely one isolated decision. It is the way apparently separate decisions and omissions combine. A report is classified evidence. It's a kind of a series of ways of exhausting a whistleblower, exhausting them by having hurdles and hurdles and hurdles and hurdles and hurdles. A report is classified. Evidence is not obtained, so you win by exhausting the other side. A responsibility is transferred, a deadline expires, a procedure closes, the reporting person is told to go to the court alone. Each step may appear limited when considered separately. Together they may create a system through which serious wrongdoing never reaches independent determination. The paper is more than 180 pages long because the problem cannot be understood through one statutory provision or one